Hello, everyone, and welcome to day 2 of Alt Legal Connect. We'll get started in just a moment. Okay. Hello, everyone. Welcome to day 2 of Alt Legal Connect. Our session is BFAB with TTAB, tips for successfully pursuing, defending, and settling TTAB disputes. This session is sponsored by McCabe and Ali. For those of you who don't know, my name is Bree Van Til. I am the Director of Education at Alt Legal. I'm also your Master of Ceremonies for Alt Legal Connect. I am here to make sure that your experience with Alt Legal Connect is fantastic. So if you have any feedback for me, let me know. I would also love for you to go to the feedback tab here in the stream and just provide us with some feedback because we want to know all the things. As a reminder, we have a very strict code of conduct. Don't be a jerk. It's never been a problem. I don't anticipate it's going to be a problem today. But just as a reminder, if you're thinking to yourself, should I be a jerk today? Nope, you shouldn't. Please don't do it. Thank you. Okay, we will be offering CLE credit for this session through the state of California. Please note that CLE credit is available for live attendance only. So if you're watching this via recording, you're going to learn a ton. You're going to know so much about TTAB. It's going to be amazing, but I can't give you CLE credit for it. I can't provide you with a certificate of attendance. You might still be able to self-apply, but otherwise I can't help you. Sorry. I do need you to be in the session for the entire 70, that is 70 minutes to qualify for CLE credit. Make sure to write down the code that I provide to you. Don't rely on yourself to remember it. Please write it down and put it exactly as it is in the survey. Note that there will not be any spaces in the code, so don't put any of those there. So put that in the survey, submit the survey. All right, so it should go without saying, but Alt Legal is a legal technology company. We're not a law firm. We're not providing you with legal advice. And while the upcoming presentation, it's going to be amazing. Jonathan's going to tell you all sorts of cool things. They're not necessarily our views. They might not be. Anyway, okay. Please do use the chat to talk amongst yourselves. If you have any questions for Jonathan, go ahead and put them in the chat, but try to start that with the word question so that it's easy for us to see what's going on. We're going to make sure that Jonathan gets all those questions. All right. I am super pleased and excited to welcome our speaker, Jonathan Menkes. He is a partner at Knobbe Martens, where he specializes in trademark prosecution and litigation. He chairs the firm's CBD and legal cannabis group. And among other clients, Jonathan also defends Monster Energy, which I feel like must require him to consume tons of the beverage to keep up with them because they are super active in all the things. Anyway, here is Jonathan.
Bree, thank you so much for that wonderful introduction, and your whole team is fantastic. I think anyone who has worked with you and your team knows that it's such a streamlined process, and I can't thank you enough for the opportunity here. So thank you again. I'm excited to share the next hour plus with the folks here who are joining. Good morning. Let me give you a quick overview as far as where we are, where we're going, and give you a little bit of a roadmap there. First, what are we talking about? It's really TTAB litigation, inter parties, opposition, and cancellation proceedings. The bulk of the talk today will be about the first few phases of things as far as the opposition's filed, the answers filed, discovery, some tips and tricks there, of course, settlement being a huge part of that. And then we'll touch on some of the differences between TTAB litigation versus district court, and hopefully we'll have time at the end to go over additional considerations. But first, what are the timelines of TTAB litigation? Many of you are familiar with this, but some may not be, so I thought it would be helpful to first go over broad strokes, what you could expect. Today, I will largely be talking about oppositions, but keep in mind the rules that apply to oppositions by and large apply to cancellation actions. So opposition or cancellation is filed. What happens? Answers due 40 days later. Then the parties are required to hold their discovery conference. I think it's worth noting that of all the deadlines in the TTAB schedule, you cannot extend the discovery conference deadline. It's a little bit strange to some. You can extend the answer deadline. You can extend all of the subsequent deadlines after the conference, but you cannot extend the discovery conference. And why is that? The TTAB does like the parties to consider settlement, and they like them to discuss it early. And that's one of the topics, of course, for those who have participated in TTAB litigation. You know that the discovery conference is mandatory. So just keep in mind, if you're in negotiations with opposing counsel or the other side, you're running up against that discovery conference date, you might as well hold it. Doesn't take that long. Don't try to extend it because the board will not reprimand you, but at least deny it and say why you cannot file an extension as to that date. Next, discovery opens. We're off to the races. We serve discovery requests. The other side serves discovery requests. You take depositions. Keep in mind, of course, you can't serve discovery on the other side until you serve initial disclosures. So be sure to do that. What are initial disclosures? It's really just a summary of the documents in your possession that you intend to use in the proceedings, as well as your likely witnesses. It doesn't have to be exhaustive, but at least it has something to provide the other side to give some sense of what the parties are dealing with. Next, after a few months, we've got expert disclosures. In my experience, experts are not necessarily always involved. It depends on the nature of the case. They can be pretty expensive, frankly, and maybe the case doesn't warrant it, depending on the facts at issue, the parties involved, and of course the budgets. I think sometimes there's a need because you want to show an overlap between two industries. Let's say your client sells one type of product and you want to show an overlap with the applicant's goods or services, and so you hire an expert to help demonstrate that overlap. 30 days after that, discovery closes. We'll talk about this later, but if you hit the expert disclosure deadline and then you're trying to serve discovery, unless you extend the dates, you're out of luck. The other side can basically refuse to cooperate or provide responses. We'll talk about a case I was involved with where this very thing happened. So if you hit the expert disclosure deadline, it's too late to serve discovery, so you either extend the dates or basically forego serving discovery. So keep that date in mind. So after expert disclosures, 30 days after that, discovery closes, as noted. Then, of course, you have pretrial disclosures, a little bit more involved than initial disclosures, any testimony depositions that you plan on taking, the subject matter, generally speaking, of what the witness will be testifying to. All of that would go in your pretrial disclosures. Then we have testimony period opening. So this is plaintiff's opportunity to submit two things. One would be a notice of reliance, basically a way of getting before the board evidence that really should just be easy and not have to argue about whether it's admissible or not. Of course, you do have to explain why the factors, likelihood of confusion factors, for instance, support, or why this evidence supports a likelihood of confusion or whatever the case may be. But for applications and registrations, you get those of record in a notice of reliance. Perhaps there's web pages, maybe there's discovery requests or responses from the other side that are really helpful that you want to get in front of the board or at least highlight. That's all areas where you'd have during your testimony period, that's when you'd get that before the board. So again, and then of course, testimony depositions, I shouldn't forget that. The opportunity for your witness to say their side of the case, why there's likelihood of confusion or whatever the claim at issue is. So a very important part of the case. We won't be going into much detail about these latter phases of discovery. Time is short, as we know, and so we're really focused on the first half of things, but I just wanted to highlight a few of the pointers on what you could expect later on in the proceedings if they should get that far. Then, of course, the same happens for defendant. They have their pretrial disclosures, their testimony period. There's a rebuttal opportunity, and then we get on to plaintiff's main brief, due 60 days after that last deadline. Defendant has the opportunity, or applicant in this case, would have their opportunity to file their main brief, and if plaintiff so chooses, they would have the opportunity to file their rebuttal brief. So what are some advantages of TTAB litigation? For those who may not like to have to go to court and exert or demonstrate their oral advocacy skills, TTAB might be excellent because it is exceedingly rare to have an oral hearing before the board unless you request it towards the end of the proceedings, or perhaps there's a time with the interlocutory attorney where you are in front of the board on the phone or via a call. It's really, everything's on paper. So For those of you who don't like to show up to court, or may not, or feel like their writing skills perhaps are better than their oral advocacy skills, maybe TTAB litigation is for you. I would say it's a fairly predictable schedule, and it's routinely extended. The dates, once an opposition or cancellation is filed and the board institutes what's called an institution order, it lays out all the deadlines coming up through the case, and it's routine that you can extend them. One practice tip I would note here is that rather than filing, for instance, a 30-day extension, I might consider a 60-day extension. This will be important as you start nearing the 9-month, 1-year mark, and the case is kind of languishing, for lack of a better word, and the board will start requiring detail. Why are you still in settlement? What's going on? What issues remain? And you'll have to report to them. Well, if you file a 30-day extension request with a detailed report to the board, it may take them 30 days or more for them to rule on that motion. Now you're back where you were 30 days ago and the deadlines have crept up again. So I think it's a practice tip there. Just consider filing a 60-day extension rather than 30. It's also the less motions you file, probably the better before the board. So just give yourself and the other side plenty of time to hopefully work out the settlement. Another advantage, and I've linked to the TBMP, which is a manual essentially of procedure. It really lays out in a fantastic way most issues that I think people face in your traditional TTAB litigation. Does it cover everything? No, but it has helpful cases in there. It has examples, and it's a really fantastic resource, free of course, that I think everyone should turn to when navigating the quagmire that is TTAB litigation. A note here, again, specialized administrative law judges, you don't have to explain trademark law to them. They know it pretty well. And that might be an advantage over perhaps a district court. I think many district court judges, he or she may know trademark law very well, but they may not. And so you don't have to explain things to the TTAB judges. They know it. So you can just go to really the substance of the case. But the TTAB is not without some disadvantages. I think one disadvantage that comes up, certainly in prosecution of your application before an examiner, but as well we have before the TTAB, they're really focused on the four corners of the documents at issue, the application at issue. So if your application covers broad goods or services, but the applicant is only doing a narrow set, I don't think the board's going to give that much weight as far as considering the likelihood of confusion factors. So if for some reason you were very concerned about the marketplace realities, why there would not be infringement, or maybe why there would be infringement, maybe district court would be a better forum. That's worth considering. Another disadvantage, potentially, if you're a plaintiff and you really want the applicant to stop using, you're not going to get the use restrictions at the TTAB. They are not looking to give you injunctive relief. They're not going to give you damages, and they're certainly not going to give you attorney's fees. They're pretty limited also in their sanctions. They're not going to award monetary sanctions to the other side, even if it's truly egregious conduct by the other side or opposing counsel or the applicant. As it notes here, they're not going to impose it or even expenses to the other party, but they may enter other sanctions such as and including entry of judgment, which is a pretty significant penalty, if you will, or sanction, but certainly not quite the same as what you might be able to get in district court if you have a truly egregious opposing counsel. And I'm confident that no one on this call today would qualify as an egregious opposing counsel. So what are some advantages of district court? Well, it's kind of inverted from the TTAB litigation. So some people like being in front of a judge. They like looking the judge in their eye and explaining why their case, why they should win their case, why their motion should be granted. Some people like that. And so you're not going to get the opportunity to get in front of the board live via video in most cases. Everything's on paper, so you take out that human element. So that is arguably a disadvantage. But if you're a plaintiff and you're hoping to get injunctive relief, possibly damages, district court might be the perfect place for you and your client to go, because certainly, as we know, damages are available, injunctive relief, and in exceptional cases, attorney's fees. We'll turn quickly to that. There's a Supreme Court case from a few years ago, Octane Fitness, that kind of changed the standard and clarified some things on the patent side of things. It essentially said that if you're going to award attorney's fees, it's properly looked at on a case-by-case basis, looking at the totality of the circumstances. It really has to stand out from other cases as far as the strength of the litigation position or how the parties have actually handled the litigation. So question, does that apply to trademark cases? This was a patent case. A number of circuits have adopted this ruling to trademark cases. There may be others here, but just a few listed below that have, in fact, adopted the Octane fitness standards. So if you're trying to get attorney's fees, just know that it's typically not easy. Maybe your case warrants it. It's very fact specific, but it's not something that's readily obtainable. Okay. What about disadvantages of district court? You could have shorter response deadlines. I think typically in TTAB litigation, you're looking at 20 to 30 days on average. District court can be quicker than that. Unlike the TTAB, district courts can vary by their local rules, in addition to knowing the federal rules of civil procedure and federal rules of evidence, knowing the local rules. And if you're practicing in several district courts that have different local rules, that could be an issue. I'm sure there are a number of smart litigators that find this very simple, but for my simple brain, I like TTAB litigation because I only have to know the TBMP and the federal rules of civil procedure and some evidence. So there's that. And again, as we mentioned, maybe the judge that you're in front of does not know trademark law that well, so there's some education going on. That could be a disadvantage if you're trying to explain why the factors weigh in your client's favor. So how do we decide which forum we are supposed to be in? Well, one question is, what relief do you need? Do you need an injunction, a temporary restraining order? Do you need this infringement to stop now, or do you just need to keep the registry clear? As we noted, the TTAB doesn't grant injunctive relief, so if that's the kind of relief you're looking for, district court, of course, makes much more sense. When do you need the relief? Are you okay if you just oppose an application and it languishes for 2 to 3 years, or do you really need this to happen right away? Budgetary considerations can be an important factor too. My sense is that district court can be pretty darn expensive, and TTAB litigation could spiral out of control in some instances. But to the extent that there's a lower budget, your client may be better served by looking at the TTAB. Again, the only issue before the board is whether that mark can register or not, or remain registered in the case of a cancellation. But maybe that's okay. And if they're on a tight budget, that might be a good forum to at least have the case heard. Business considerations, again, is this a competitor that's using a mark? They're using it on social media. You really need a court to enjoin this activity. You're not going to get that at the TTAB, so district court would make more sense. Okay, now that we've kind of gone through the considerations, now we're on to pre-filing. So I'm the opposer, I'm representing the opposer, I'm looking at the applicant. What am I doing? I'm doing a pretty thorough use investigation. I'm looking on social media. What are they posting on Facebook, Twitter, Instagram? I go to LinkedIn. How big is this applicant? How many employees do they have? Do they have 10? Do they have 1,000? I would like to know the kind of applicant I'm dealing with. And I think social media and the internet is ripe with information and ways that you can figure out how big the applicant is. How big the applicant is might mean how much budget they have, and how much budget they have, how much they might dig in their heels. Not always the case. Certainly there are applicants who are pro se who will dig in their heels despite the merits or lack of merit of a case, but it's certainly something I'm considering when I'm doing my diligence when it comes to the applicant. Besides the applicant we talked about, are they pro se? Are they going to understand TTAB procedure? And that will impact whether I involve and how much I involve the interlocutory attorney. So that's something to consider. Are they a domestic U.S. applicant or a foreign applicant? I don't mean this in a discriminatory way, but I think my general sense is that foreign applicants and just foreign entities in general tend to not appreciate how different U.S. litigation is from perhaps Europe or elsewhere. They may be familiar with depositions, but discovery requests certainly is something new in many instances, and the costs are significantly higher, can be significantly higher in U.S. matters. And so for applicants that are a foreign applicant and they filed in the U.S., either through Madrid or some other designation, they may be more likely to enter into use restrictions or an agreement or a limitation rather than fighting. Again, not a generalization, does not always happen. Certainly you could have a domestic company that's rather small and is willing to enter into settlement more quickly than a foreign applicant, but just a consideration. Is this applicant expanding? Did they have 100 followers a month ago? Now they have 1,000. Is there a rapid expansion in their growth? Is there a geographic expansion or the goods or services with which they're using? Maybe they were limited to high-end wine and now they've expanded out into water or energy beverages. Not to say I'm going anywhere with that, but it's a consideration when it comes to how are they expanding and how does that impact the likelihood that my client will file or one of my clients will file an opposition. Again, followers, I think it's a different situation if you have 100 versus 5,000 versus a million, certainly. And the other consideration, I think, and many of you know this, fully expect that your opposition or any cease and desist letter that you send will appear on social media. So if that's the case, just keep that in mind. Maybe you tone down the language a little bit. Certainly something to consider in today's age where you can post, and people do post everything. Funding. Okay, so maybe the applicant seems rather small now, but lo and behold, there's an IPO about to happen. That's something to consider. Maybe they have a Series A or Series B round of financing. Is it $1 million? Is it 10? Is it 100? These are all considerations to think about when, at least when I think about when dealing with an applicant. Best and worst outcome, certainly best outcome you win, worst outcome you lose, but being a little bit more detailed in how we think about this. What is your client's objectives? Are they trying to keep the registry clear? Are they trying to stop use? And if the case is rather weak, what happens if it goes all the way to a decision and you have a negative judgment entered against your client? How will that impact future enforcement efforts? Certainly costs are a consideration in every respect. So again, what are the key objectives? Are they trying to keep the registry clear? Are you trying to leverage this US opposition to enter into a global coexistence agreement? I've had a number of clients who maybe they'd win in the US, but they'd lose in Europe and Japan and China, but they'd rather lump everything in to the US opposition cancellation agreement. So that's something to consider. And the reverse would be true too. Maybe they win in those foreign jurisdictions, but they lose in the US, but you still file the US application or opposition rather with hopes of negotiating into a global coexistence agreement. Reputation is certainly something that matters and something I look at. If I'm the opposer, has the applicant filed a number of applications? Did they walk away each time? Did they fight? What were the merits of those cases? Again, not making any determination as far as what's going to happen, but at least sort of reading the tea leaves of what may happen in the opposition and advising the client accordingly. I know a number of you are familiar with this, but for those who are new to TTAB litigation, here are a number of grounds, just a few examples. This is not exhaustive. Likelihood of confusion is probably the most common one that you deal with. Dilution, so the registration mark will dilute a famous mark that you have registered or your client is using. And merely descriptive, generic, certainly a basis, the mark has been abandoned. That's typically in a registration where you're petitioning to cancel or your client is petitioning to cancel. The two that I think don't get enough attention and I would absolutely consider looking at are these last two. Lack of use prior to filing a use-based application. So if you do some digging, we'll talk about this in a little bit more detail, but you do some digging on the registrant or the applicant rather, and you notice that, hey, wait a second, this is what, when I say applicant, I mean respondent in the case of petition cancel. You look at the registration, you say, that's interesting. They say they've been using on all these goods and services, but when I go to the Wayback Machine, for instance, the Internet Archive, I don't see any evidence of that. You hire an investigator, they do some digging, they don't see any evidence of that either. Okay, great. Well, I've now got a basis for seeking to cancel this registration. This came up fairly recently with a case or two of mine not that long ago where we had a Chinese business entity filed an application. It predated my client's application date. It did not predate my client's first use date. And when we looked at the goods and services in the application of this Chinese application, medical devices, gaming devices, glasses, soda. It seems like a little bit suspicious that they'd be offering all of these goods and services. Just saying. So I think it's important to really dig in and think about, okay, what are the odds that this company is producing both medical devices, casino games, and beverages? Seems very unlikely. You file an opposition on the basis that it's a use-based application, so you file an opposition on the grounds that there was lack of use prior to the filing date of a use-based application, and that's a grounds for challenging it. They give you a letter of consent, they narrow the goods, and everyone's happy. Same consideration for lack of bona fide intent. I think this may come into play with foreign applications that list everything from laundry detergent to, again, medical devices, Christmas trees. Wow, they sure offer everything. Are they Costco? So in any event, I think it's worth considering. Do they really have a bona fide intent? That may not come out until discovery, but you could certainly allege it. Okay, it looks like there's a question. Bree, should I stop now and answer that, or should I wait till the end?
Jonathan, it's totally up to you. You can answer the questions as they come up if you feel like they're appropriate. Otherwise, you can just go ahead and save those for the end. So
Terrific,
don't feel any pressure to answer them immediately.
Excellent, excellent. Well, I think I feel compelled. I see a question. I feel like I have to answer it. So I think I will go ahead and do this. So the question was, what advice do you have for dealing with an aggressive pro se opposers who are not attorneys and do not have to necessarily follow the same ethics rules an attorney? So this doesn't happen that often, but it does happen. We'll actually get to this question in the involvement discovery conference, and I think that's probably the best place, or the first place you can really rein in an aggressive opposer. But great question, and we'll answer that in just a slide or two, I think. Okay, before getting to that, though, I think it's worth noting, again, you're the opposer, and you're looking at ways that you can consider opposing someone's application, but maybe this other side has a registration. So things that are worth considering, you don't have to file a Section 15 declaration for a mark to be considered incontestable. What is an incontestable mark? It doesn't mean it cannot be challenged in any respect. It just means that the grounds are limited. So likelihood of confusion after 5 years of registration, again, you don't have to file that Section 15 declaration. It's good to do so, make it of record, but if your client for some reason forgot to do that, that's not the end of the world. If it's registered for 5 years, that's sufficient. It's basically a statute of limitations. And what does that mean, incontestable? So it narrows the scope of the grounds that an opposer can assert against a registration. They've abandoned it. The mark has become generic. They procured it through fraud. And then these last two, again, lack of use prior to filing use-based application or lack of bona fide use as of the filing date of the intent to use application, all fair game still with incontestable marks. So keep that in mind. Okay. I'm seeing this more and more, and I'd be curious if those in the audience are also seeing this more and more. When an opposer files a likelihood of confusion claim under 2D, they often throw in a 2A claim, but they're different. And I want to make sure that people understand that the 2D and 2A are not equivalent, and you should not always include them just because other people do. So again, 2D is likelihood of confusion. Registration of applicant's mark will cause likelihood of confusion based on the DuPont factors. What is 2A? I think of 2A as essentially the right of publicity, but in the trademark trial and appeal board context. So what are the elements? One, mark is the same or a close approximation of the name or identity of the opposer. Two, the mark is recognized as such. It points unmistakably to plaintiff. Plaintiff is not in fact connected to the goods or services. And lastly, plaintiff's name or identity is sufficiently famous that a connection would be presumed. There was a case from last year called Reagan World, where an applicant had filed an application to pursue various news offerings and publications under the mark Reagan World. There, the opposer won on the 2A claim because they were not affiliated with Reagan, former president, or their estate, and therefore a 2A claim was held to be proper. Here, as you see in this TTAB 1993 case, the board found that Olympic champion was not found to be a close approximation of the name or identity, of the United States Olympic Committee, that they're different. So why are we going over this? When it comes to motions to dismiss, we'll remember that you want to state a claim that's plausible. And so don't just throw in a 2A claim because you think everyone is doing it, so I should do it too. I think really save it for those occasions where there is likely to be a false connection between your client because they're so well known, even in a different industry, and you need to assert that. So just wanted to have that practice pointer there. Don't confuse the two. Okay, moving on, special considerations. Did the applicant make false statements during prosecution? If they got the first date of first use wrong, probably not sufficient to cancel or oppose their application. If they submitted a terrible specimen, questionable whether that was or wasn't. If they fabricate a specimen, that probably is sufficient. So it really depends on the nature of what they've done, but I'm absolutely looking at all of these things when I'm looking at the applicant, or if I'm filing a petition to cancel, I'm looking at this from the registrant. And again, no bona fide intent, always consider that, and lack of use as of the filing date. So minor distinction here, but worth noting. It's not that they got the first use date wrong. They said that they've been using for 10 years and it's been 1. That's not necessarily a ground for canceling a registration. But if they say they've been using for 10 years and they used after their filing date of a use-based application, that could be grounds. What about the applicant? Because not everyone represents opposers. I also represent applicants, big and small. And so what are the considerations on their side of things? Well, I'm looking at pretty much the same factors, a few different ones that we'll note here, but how big is the opposer? Is it a pro se opposer? This goes to that question that we got a moment ago. What do you do when you're dealing with a pro se opposer who doesn't understand TTAB litigation and does not understand the rules of the game, in other words? So I think involving the interlocutory attorney is very helpful. That's certainly one way to do it. And using all the weapons at your disposal, maybe a motion to dismiss is appropriate, and maybe even a summary judgment. It really depends on the facts, but certainly there are tools at your disposal to use. Domestic versus foreign, I think the same considerations apply. A foreign opposer may or may not be as aggressive as a domestic company of equivalent size. Again, they're not used to, in my experience, they're not quite as used to the costs of things in the US, but that's not necessarily true. Just because I see a foreign opposer doesn't mean I say, oh, we're going to win this one, slam dunk, they're going to walk away. Not so. Every case is different, but it at least is a consideration. Use and incontestability, again, can I look at, when I look at opposers' registrations, are they incontestable? Are my grounds limited? Can I counterclaim against them? Is this opposer deeply funded? What is their enforcement history? Have they sued a number of people? That's certainly a worrisome consideration if you're the applicant and you've got this opposer out there who sues everyone left and right. And again, what's the best and worst outcome? I win the opposition. I successfully defending my application, but my client has spent $150,000 or more dollars. Is that a win? Depends who you ask. Worst outcome, you lose, but are they really precluding your use? We'll get into that. And certainly cost. So again, factors that you consider as an applicant. Okay, going back to opposer, I've seen this happen a number of times, and I just want to at least flag it for you to consider. Even if you have a registration as an opposer, should you assert it? A few different schools of thought here. One consideration is, and some very large companies do this, they only assert common law rights. Well, why would they do that? Well, by only asserting common law rights, they're not putting the registrations at issue. The applicant would have to separately file a petition to cancel, ask the board to consolidate, and then bring them into issue. So they can't. There's nothing to counterclaim directly there. Procedurally, they have to go through some hoops. Does that really get you to where you want to be? Hard to say. I don't have that many clients who only want to assert common law rights, but be careful if you're doing so, and be specific in your pleadings. We'll talk about this again in the motion to dismiss section, but to the extent you're saying the marks are confusingly similar, the goods are the same, we've been using for 15 years. Well, that's great. What goods and services have you been using on for 15 years? And where have you been using, by the way? Nationally, only abroad? That matters. So I think you need to be very careful if you're going to assert only common law rights, that you know what the scope is of those and plead them properly. So if you assert the registrations, like many of us do, be careful of the first use dates. Maybe I have a registration that just issued last year. The client's registration issued last year. The applicant is an intent to use application. But during my use investigation, they've been using for 3 years. So they actually predate us. Well, I'm probably not going to assert that registration because I don't want it to be subject to cancellation. So again, first use dates, be very careful with that and make sure you're doing your diligence and homework on the applicant. Okay, another practice pointer here. If you're a routine player in TTAB land and you've got 10 or more registrations, I've had the board state on several occasions, can you please put a chart together that summarizes the mark, the goods, the first use dates? It's very helpful for them. They like to quickly see whether priority is or is not at issue. So be kind and do that. As an opposer, I don't have to say this, but I'm going to say it. Ethical considerations. I don't know how ethical this pro se opposer is. They're not bound by the rules of conduct that each state has. But certainly you have to have grounds for what you're asserting. You can't just make something up. We all know that, so we'll leave that as it be. As the opposer, surviving a motion to dismiss, don't include claims that are, if the applicant is watching this video or hears about it and realizes that motion to dismiss is a pretty awesome tool, you want to be prepared that you would survive that motion to dismiss. So if the claim is kind of shaky, I would consider omitting it altogether, especially if you're trying to get a quick resolution of things, because once a motion to dismiss is filed, you're delayed several months. Okay, the opposition has been filed. Now what? So the opposition is filed. I'm representing the applicant, or I am the applicant. First thing I'm looking at, does the opposer have standing? Standing requires two elements. First, they have a real interest in this proceeding. It's a direct and personal stake in the outcome. They can't just be a theoretical, I don't like the opposer, I think they're a bully, I'm going to seek to cancel on that basis. Probably they don't have a real interest in the proceedings. And 2, reasonable basis for a belief of damage. You have to allege why you have the belief and why that is a reasonable belief in damage. Having registration for similar goods or services is, of course, a great way of establishing standing. But if you're an applicant, I'm looking at that. Okay, motion to dismiss. A motion to dismiss. So again, this is a way to eliminate actions that are fatally flawed in their legal premises and destined to fail. As we all recall from Iqbal and Twombly, really the standard is because if you have not nudged the claims across the line from conceivable to plausible, the claim must be dismissed. I have a few practice pointers here. The board may be reluctant, more so than a district court, to grant a motion to dismiss. Does that mean you shouldn't file one? Not necessarily. I think motions to dismiss could be underutilized, and I don't think they're terribly expensive to put together. And even if you don't win, ultimately, and the claims go forward, maybe you've narrowed the claims. I had 2 instances where the opposer, I was representing the applicant, and the opposer included a 2A false association claim. We thought there's no way you're winning on this. We're moving to dismiss. Yes, we of course included the likelihood of confusion claim, but really it was targeted at the 2A claim, and they withdrew it going forward. And they further amended their complaint to be more specific on their common law allegations. And so I think that's a great example of where you can narrow the scope of claims just by filing a motion to dismiss. What else does it do? It delays the case. Sometimes applicants like to delay things, and so by filing a motion to dismiss, you have basically pump the brakes because there's no answer due. You file your motion to dismiss, the opposer responds, you have a reply, the board looks at it, probably waits 3 to 4 months, sometimes longer, and then either grants it, which is a win for your client, and if they don't grant it, maybe they grant it in part. In this case here, I had a situation where the board again narrowed the scope of the claims. That's a win. So I think it's worth absolutely considering a motion to dismiss as the applicant, and so make sure you keep that in your tool belt. Okay, again, you're the applicant. What are you thinking about? I'm thinking about counterclaims. Again, looking at the registration, are there any defects that we talked about? No use as the filing date, etc. And standing is presumed. You don't need to separately prove standing. If you're the applicant and file a counterclaim, it is presumed. It's a matter of law. Okay, affirmative defenses. I love this topic. So one thing I find very common is that if I'm the opposer and I see the applicant, they almost always will say something along the lines of affirmative defense 1, opposer fails to state a likelihood of confusion. Okay, you can do that. Certainly that's, you're entitled to say basically whatever you want. Why is it improper? Well, denying a likelihood of confusion claim or whatever the claim is not an affirmative defense. An affirmative defense is laches, acquiescence, estoppel, etc. Maybe there's infringement or maybe there's a likelihood of confusion, but it's excused because X, Y, Z. I typically don't include affirmative defenses unless I've got a grounds. I reserve the right, of course, to assert them if I'm the applicant. But as the opposer, if I see something like that, we'll talk about this in a moment, I'm calling you out on it. And unless you've shown your case, it's getting stricken or it's getting taken out by the board, which we'll talk about now briefly. Here are some affirmative defenses. We won't have time to go into these because I know this is just so exciting and we've got a lot to cover. The one that I will point out is that the Morehouse defense, if an applicant already has a registration for pretty much the same mark, pretty much the same goods, maybe there's no, that's an affirmative defense I would absolutely plead because registration of this new mark is not going to cause added injury to the opposer. So keep that in mind. Terrific. And I see questions popping in, which is amazing. And so I think I will continue for a bit, and then maybe at the end we will get to those. But thank you. I love the questions. Thank you so much for the active listening here. It is greatly, greatly appreciated. Okay, more considerations here for the applicant. When do you answer? Does your client really, really need that registration? Maybe not. Maybe they're okay using, and you're not really worried that the opposer is going to sue your client for damages or try to get an injunction. So maybe you can just walk away. You just say, okay, well, we'll withdraw our application and you've saved your client a significant amount of money, potentially. Same thing with the registration. Is it an older registration? Is your client not using it? Does the other side just want a consent agreement? What have you? So do you really need what you're fighting over? I think that's always worth asking. Again, the cost can be pretty significant. I think one of the questions here is, what is an average cost? It can be pretty significant. It depends how far along you get in proceedings, but it ranges considerably. So hard to give any kind of immediate cost, but it really depends, of course, the size of the law firm and the motion practice. That all plays into how much something could cost. Again, the longer you go in the proceedings, you get to a final decision, you're talking a very different number than discovery, initial disclosures, discovery conference, probably a very different number there. Okay, so what about the threat of infringement? So again, you have an opposer who's very aggressive, but only at the TTAB, and they're not aggressive. They don't file a lot of lawsuits, or it's a foreign opposer. And you think, okay, the threat of them actually coming after me or my client is low. If I pull out of the case early, how do I worry about B&B hardware, which we'll talk about very quickly. So for those of you who remember from several years ago, there was a question, well, what happens if you fully litigate a case at the TTAB? Does that have preclusive effect in a subsequent district court litigation? The answer is yes, but all of the elements have to be met for res judicata or claim preclusion to apply. So I think it's a question that people should definitely consider. I'm not aware of cases, and maybe someone in the audience is aware of a case, but where an applicant drops out very early in a TTAB litigation and the opposer then goes off to district court to say, aha, I've got a judgment entered against the applicant. Let's say they filed the answer, but that was it. They walk away, a judgment is entered, and now the opposer says, I can get an injunction based on the TTAB outcome. My sense is that it's unlikely to happen, can't guarantee it, but that's very different than you fully litigate a case, it's decided on the merits, you've had depositions and discovery, and you've fully duked it out, and then you walk away, or there's a judgment, probably a different situation if you are the applicant. So it's worth considering if you can walk away, or should walk away. I'm gonna pause for water so I don't have cotton mouth by the end of this proceeding. I'm having so much fun, so I hope you all are too, and I see more questions and keep them coming. Okay, so the answer's been filed. I'm the opposer. What am I looking at? Did the applicant file any counterclaims? That would certainly change the dynamics of things. Do I now have to get marshal evidence or be prepared to marshal evidence that we've been using as of a specified date? Did they file a motion to dismiss? Do I have to deal with that? And what are their affirmative defenses? We talked about that briefly, but it's worth mentioning again. I would absolutely involve the interlocutory attorney if the other side is including affirmative defenses that are just either baseless or insufficiently pled. Where would this come in? If you're the opposer or the applicant and you want the board participation, I think this is also an underutilized tool. I think the interlocutory attorneys like the opportunity to meet the parties via the phone or teleconference 10 days before the discovery conference deadline, at least 10 days. Make sure you're filing that motion to have the board participate. I think the interlocutory attorneys are fantastic and really want to help the parties resolve the matter and really narrow the scope of the issues. So if I see an affirmative defense in there that I think is questionable, I'm involving the interlocutory attorney. Why am I doing that? They will sua sponte strike an affirmative defense if it's not adequately pled. They may or may not give the other side, the applicant, the opportunity to amend it, but at a minimum, I think you're making yourself look great in front of the board as an opposer if at the gate they're already doing something negative to the applicant. So again, affirmative defenses, you don't have to file a motion to strike. You just set up the phone call. The interlocutory attorney will go through the case and read over the pleadings. They'll verify standing if you're the opposer, which is great to have that checked off the list. And again, affirmative defenses, if you've only said something along the lines of opposer engaged in unclean hands, period. Not adequately pled. Okay, so you have to have more than that threadbare bones accusation. You have to say why the opposer engaged in unclean hands and why that's or estoppel or whatever the affirmative defense may be. You don't just say make conclusory statements that it was unclean hands or acquiescence. You have to give some meat to that. I think it's very helpful. Many of you as opposers have dealt with pro se applicants, and they, no fault of their own, they don't understand the process. It's a very different world in many respects, and a lot of procedural issues can come up. The board is very good about thoroughly going through every single major rule over with the pro se applicant. If I'm dealing with an applicant who's pro se and they're very difficult, I'm definitely involving the board there to kind of rein them in and help them understand the situation that they're in. Okay. I apologize for the false advertising here. It's not really a war story. It's more of just an anecdote, but I thought war story sounds cooler, so there it is. Bullying is not an affirmative defense. So applicants out there thinking that there are overly aggressive opposers and want to plead bullying, the board has recognized on a number of occasions that that is not a proper affirmative defense. There's a case cite there. Trademark owners are entitled to protect their rights in registered trademarks by seeking to preclude registration of what they believe to be confusingly similar. So you can put that to bed. Okay, discovery. Probably the most interesting aspect of a case, and this is where things can get pretty expensive pretty quickly. Your client serves discovery as the opposer, and applicant serves discovery. You've got to respond. Maybe there's a motion to compel, and excuse me, this is really where things can get quite expensive pretty quickly. Timing of discovery. So there was a precedential case from a few years ago that answered the following question. As we know with office action responses, if the deadline falls on a Saturday, Sunday, or a holiday, you get the next business day to respond. Okay, well, in 2017, the board had updated its rules on discovery and said that the applicant has to have adequate time to respond to discovery requests. Okay, well, here the petitioner said, all right, well, my deadline to file 30 or to serve 30 days ahead of that deadline is Sunday. And because of this rule that any date that falls on a weekend is extended to the next day, I'm serving my discovery request on Monday. Well, that was too late because due to the timing of things, if they served the discovery request on Monday, that made the response deadline due after the close of discovery. And under the new rules, that was impermissible. So as noted here, very important, you have to serve discovery requests, again, initial disclosures first, and then serve discovery requests with at least 31, not 30, 31 days remaining in the discovery period. It doesn't matter if you serve on a Sunday, Friday, a holiday, that's the deadline. As we mentioned before, if you hit the expert disclosure deadline, it's too late. Serve before then. I think serve well before then. Don't put yourself in a situation where you're counting the days and worrying, oh shoot, did I serve it on the wrong day, or do I have enough time? Does the applicant or respondent have enough time? I think serving early fixes that, but if you don't, here we are. This is the case. It's precedential, so make sure you know that. So again, date of service is not counted. If I serve today, that's 31 days from service. Tomorrow starts the clock, so that's why it's 31 days and not 30. Hopefully that's clear. I know the rules changed and it made a lot of confusion arose out of that, but we can talk about that more if needed. Okay, so I'm the opposer. Stay focused. This is not a scorched earth approach. No matter who you represent, I think it's very important to be tailored in what you're looking for. Why are you asking for this discovery? Don't just use 75 because you can. And remember, this includes subparts. So you may have 10 questions with 25 subparts each, and that's a lot of discovery requests, and the other side might not have to respond. And so you don't want to be in that situation. Keep it focused. A note here on motions to compel. When you get the responses back from the applicant, let's say, if you're complaining that they have been dodgy in their responses, make sure that you're not dodgy in your responses too. It looks pretty bad when when you file a motion to compel and the applicant comes back and files the same motion and basically says, well, everything that opposer is accusing me of, they did. It's not a true and clean hands, but I think you look bad in front of the board, and we all know we like to look as good as possible in front of the board. So keep that in mind. Another point here, you have discovery. You get some interesting information, whether it's during a deposition or discovery responses. Are you in the right forum? Is there something very interesting you got from the applicant that maybe there is actual confusion? Maybe there's a lot of evidence of actual confusion. Maybe as opposed to you're in the wrong forum. And if your whole goal all along was to stop their use, again, you should be in district court in any event. So just a note on that. Okay, you're the applicant and you're thinking about discovery. Do you really need it? Not always. If the allegation is that applicant's mark is generic, it's descriptive, they've abandoned it, how much discovery do you need of the opposer in order to effectively defend that claim? Maybe you still need some, worth considering, and if maybe standing's at issue, you want to poke around at that, but I don't think you need all of their first use dates and the trade channels and all of those things. Probably unnecessary, again, if it's that applicant has allegedly abandoned its mark, so keep it focused. Again, if I'm the applicant, I'm looking at the file history. At this point in discovery, I'm asking questions about the registrations, how have they used it, I want evidence of use, and maybe I look at the ones that they didn't assert. That's interesting. Why didn't you assert kind of some of your marquee registrations? Is it because you're worried that there may be a defect in it? I'm going to poke around on that. And certainly if there's a common law issue, or if they've alleged only common law likelihood of confusion and priority, I want to know the scope and limits of that. It can't be that they've used it in every single state for 35 years on every single good and service. No, it's got to be more limited than that. Maybe that limitation is enough to avoid a likelihood of confusion claim. And again, as the applicant, maybe it's time to walk away. Maybe your client was willing to spend a few $1,000s in answering and maybe going through the discovery process. Maybe they were willing to go even through initial discovery, but they're not willing to spend 50,000, 100,000 or more to defend this thing all the way from beginning to end. Maybe they can walk away. So that's a consideration. And then filing a declaratory judgment action of non-infringement. I've seen this in a number of cases where the applicant is going along and they see the opposer and they have a number of depositions outstanding or maybe something else. And they say, I don't think there's any infringement. I don't really care about the application, but I don't want to get sued. And I got a letter from the opposer 6 months ago or 9 months ago that says my client is allegedly infringing. I'm going to prove that it's not. And they go to district court and they file a declaratory judgment action of non-infringement. That will very likely stay the case at the TTAB. So that's a consideration too. Are you in the right form still as an applicant? Even if you've gone through discovery, maybe there are reasons to still move it elsewhere. Pause a moment for a second before we get into this next juicy topic and my favorite by far. Okay. I think settlement.
Actually, real quick.
Sure. Yep.
Since you're paused anyway.
I'm going to take another sip of water then.
Yes, drink water. It's good for you. It's CLE code time, everybody. So get something to write with. And here we go. Your code is 5 argues 8. That is the number 5. The word argues the number 8. Okay, carry on.
Carry on. Terrific. Thank you so much, Bree. I wrote the code down myself. Terrific. So settlement. Consider this at every stage of the proceeding. It's not, I don't think it's up to the client to tell the attorney, you, that they want to settle. I think you should be thinking about it all the time. What is in the best interest of the client? Do you think resolving it, maybe they have to make some concessions and the other side does too, and it resolves the matter, everyone goes away, and you button things up nicely for them. Sometimes the client's objectives change. Initially, maybe it's the opposer and they want to keep the registry clear, but after 9 months of duking it out with discovery, and they realize the applicant's not going to back down, they realize, okay, well, maybe settlement is an option, or maybe you as the attorney realize that settlement is a good thing if they could just narrow the scope of the ID, maybe enter into some use restrictions that resolves it. Have finances changed? I think this and the business circumstances changing, certainly a major consideration. Let's say your client's about to be sold or acquired by another company, and that other company doesn't really care about pursuing the opposition or defending the application, the opposition. So that's certainly one reason to consider settlement. Business circumstances, again, how much does this registration mean to the applicant, or how important is it to block this application for the opposer? Very important. Certainty, I think, could also be a little bit, I think there's a tremendous value in certainty, and settlement provides that for the parties. So sometimes your clients might be a little bit risk averse, or they want to know, given a diligence matter that's occurring, hey, I want to button this up ASAP. Okay, well, wrapping things up with settlement might be a nice way of doing that. When you're thinking about settlement, I think this is really where our creative minds as attorneys can come out, and I think it's my favorite part of TTAB litigation is the settlement piece, and looking at all the different ways that you can resolve an issue. I don't think it's just a simple, okay, we've coexisted for a long time, that's it. No, maybe using a house mark, or maybe both parties use the respective house marks, and that's enough to avoid a likelihood of confusion. Or maybe there's certain trade dress that really distinguishes the parties, or maybe the trade channels are extremely different. Maybe your client is only business to business, the applicant is business to consumer. Maybe it's a very different market, high-end wine versus table wine. It really depends on the factors, certainly, but keep your mind open and always be thinking in ways that you could resolve things. I think it can be very expensive, as we've mentioned, to defend or pursue these things to the end. And if you can resolve things when the marketplace has spoken that after 10, 15 years of coexistence, there hasn't been any actual confusion, perhaps it's time to look at ways of coexisting. Maybe an assignment license back could work, depending on the party, depending on the goods and services. That's worth thinking about. And lastly, this may be underutilized as well. Maybe a business discussion between the CEO of your client and the CEO of applicant. Sit them down at a table if it's safe to do so, or a Zoom call. Sometimes the business folks, he or she may be able to convey what's really concerning them better than the attorney. Not always, but sometimes. Or if you've got a really aggressive opposing counsel, and the applicant or the opposer is actually quite reasonable, or the CEO or in-house counsel is quite reasonable, maybe that's a time to involve the reasonable folks in engaging in settlement discussion. Nice to have the lawyers involved, but not necessary, and certainly the lawyers can help draft an agreement after the fact. Okay, another consideration here, foreign filings. We mentioned briefly in the beginning of this presentation that you could have a situation where you really want a registration in Europe or Japan. Not Japan, excuse me. Japan does not, I should note this, Japan does not allow coexistence agreements. China and a number of other countries do. So you want to consider whether foreign filings can be wrapped up in this U.S. opposition. The board is pretty liberal in granting extension or suspension requests in order to wrap up those discussions. So I think it's absolutely necessary to the extent that your client has international presence or multiple marks worldwide. Maybe this is a good way to wrap them up in one. Excuse me. As I mentioned, I've been in situations with clients where we've used first, but there's an application that predates us. All we need is a consent agreement, and so I'm looking for ways to gain leverage on the applicant in order to give us a consent agreement. Sometimes sending a letter is enough, sometimes filing an opposition is enough, but always look for possible defects and ways that you can get that leverage to get the consent agreement that you need in order to register your mark. Sometimes the PTO will reject it. I think it's pretty rare for that to happen. If the marks are identical, the goods and services are very close, it's probably very hard. But to the extent you can point out the differences and really lay out the trade channel differences, the consumers, maybe they're highly sophisticated, maybe it's medical purchasing agents for a medical device, maybe the surgery is very different that these products are used in. So I think always be thinking about ways that you can point out the differences to avoid confusion. What about paying money? This is a very interesting topic because on the one hand, you might think, okay, I can spend $50,000 to see this case to the end, and maybe I have a 50% chance at winning. Or I can pay the other side $10,000 and wrap it up right now. I mean, that's a really hard consideration, and clients kind of run the gamut as far as which avenue they prefer. One consideration is, are you somehow encouraging infringement by you pay this one applicant? Are you a repeat player at the TTAB such that you think I'm never paying a dime because that'll incentivize other people to spend the $300 or so for an application just to get an opposition filed against them and they get paid for it? It really depends on the situation of the opposer, what they're trying to accomplish, and so I think those are considerations, but certainly monetary payment on either side, the opposer or the applicant, is worth considering. How does settlement impact future enforcement? By entering into this settlement agreement, are you somehow harming your ability to enforce against very similarly situated applicants in the future? Or is this actually helping you because it shows that, hey, I've gone out, I've opposed, and they've narrowed the goods and services as such, or they're entering use restrictions as such to avoid confusion? So it may help you, but certainly worth thinking about what is the enforcement policy and is this in alignment with it? Are there business reasons not to have use restrictions? I think depending on the size of the company, it may make sense not to have use restrictions. If you think about it, if there's turnover with the CEO or in-house counsel, but the business is expected to follow, of course, these use restrictions in perpetuity, unless, of course, the market's abandoned or something else in the agreement terminates it. So why put yourself in the situation of having use restrictions when you're very much setting up your client for a potential breach in the future, especially if there's high turnover? So there could be business reasons not to have use restrictions, but there may very well be situations to have use restrictions. So keep that in mind. Okay, and Breed, are we at the 10-minute mark? Is this the Q&A time? Should I blast through just skip to the end? Okay, terrific. So I'm going to fly through the next 14 slides very quickly. Essentially, district court, the main takeaway here, I'll just skip to this slide. Some people choose to send a cease and desist letter. Some people go as far as to drafting a complaint and attaching it to the cease and desist letter. Some people take it one notch further and they file, but they don't serve the complaint. And lastly, some people file and serve the complaint and they initiate a formal lawsuit. There are pros and cons to each of these. I think unless you and until you file and serve your complaint, you're probably not doing yourself that much of a favor. There may have been a time where attaching a letter to a complaint was sufficient to get things the other side to comply. But I think nowadays, with people knowing, well, unless they serve me, I'm technically not in a lawsuit, they don't really do anything. So just worth considering. So I think that's all I had there. Draft complaint. Other considerations, letters of protest, which the Trademark Modernization Act is going to change this December, so make sure you watch out for that. UDRP complaints, if there's a domain name that uses your client's mark, certainly that's worth looking into. And the DMCA, if there's a copyright issue, certainly that's an alternative method to litigation or TTAB practice there. So I think there's now time for 10 minutes of Q&A. Is that correct? Excellent. Okay. So scrolling up, because I got a number of questions, and again, thank you so much for everyone who has done this. Okay. Someone is asking about the false or falsified specimen of use. I think that might be outside the scope of this talk, but certainly it's worth thinking about. If you find in discovery that that the applicant or the registrant in this case has a falsified specimen, you get that through discovery, I would probably amend the pleadings and figure out, okay, well, put that in issue, alleged basis. My sense is that the board is fairly liberal in allowing motions to amend even pretty late in the game, especially if you discovered it after discovery requests were responded to. That's another reason why you'd want to serve discovery early rather than late, is to try to get that information sooner rather than later. So great question. What is the average cost of TTAB litigation for a client? I don't know that there is an average cost, because a lot for me depends on A, am I representing the opposer or the applicant? B, what are they trying to accomplish? I've had some opposers that they just want to file an opposition. They're pretty confident that the other side is going to default. So the budget there, very different than if you are filing a number of oppositions for the same client and you fully expect that the applicant is going to dig in their heels and put up a fight. So hard to say with any degree of certainty how much something would cost. It really depends, again, how much discovery is served. Are there motions to compel? Are there motions for summary judgment? Are there counterclaims? So many factors go into the cost of things. We do have a sheet that kind of lays everything out, but that's for another day. But great question. Yes, it can range widely. Okay. Another question here. When claiming that opponent's first date of use is incorrect, will the opponent only need to show evidence of the claimed use date, or will they also need to show a consistent interstate invoices since the claimed date? It's a great question, going into the weeds of the TTAB practice and what evidence is sufficient to show interstate use in commerce versus what is not. At a minimum, I think you should have an investigator, if you haven't done so already, have an investigator look at what we think was the actual first use date, and if that first use date was sometime after the filing date. If it was a day later, a week later, a year later, that may not matter. The type of use will be relevant, but certainly for the claim, for asserting a likelihood of confusion claim, or a lack of use as of the filing date claim in an opposition proceeding, is certainly something you want to dig up and get in front of you. You may have to wait until discovery to get that, but how much use is sufficient to satisfy interstate commerce? There are cases that talk about it. I recall that there was the Adidas case where I think it was 2 hats sold out of state was sufficient to show interstate commerce. But you could have a number of cases where there's hyper-local, like a brewery in San Diego, that they're only selling hyper-locally. Maybe there's a one-off brand or something like that. I think it's an open question, or at least it's not a slam dunk that that would necessarily constitute use in commerce. So great questions, worth certainly looking at. Oh, fraud. I love fraud questions. Okay. Question here. I know that fraud is really hard to prove. That's correct. When an applicant signs a declaration that it has no knowledge of another party with superior rights, but the applicant has clear knowledge of a conflicting registration. So, for instance, I think they're thinking of an example where the applicant got a cease and desist letter, it looks like. Is the applicant obligated to disclose that registration in the application? What is the recourse if it does not disclose? It's a great question. I think that would require offline discussion as far as the answer to that. Certainly, an argument can be made as far as the opposer and signing something with full knowledge they received a cease and desist letter. Is that a basis for fraud? Unclear. Is it a basis for lack of bona fide intent to use? Possibly. So I think that's definitely worth looking into, but I think very fact specific and would need to be looked at very carefully. Sorry for the evasive answer there, but some of these questions are very tricky and do require a bit of nuanced discussion. Okay. Question. Can a default judgment be used in district court as res judicata in an infringement claim? It's a great question. I think it depends. I know everyone hates that answer, but we certainly need to be careful in having broad stroke, bright line rules in this, what I think is a little bit of a murky area. As I mentioned before, if you fully litigated the case, if there's a decision at the TTAB, the parties have submitted their briefs, the arguments, the evidence, all of that, I think that's a different risk than if there's just a default judgment and the applicant walks away. How big of a difference is that risk? I think it really depends on the district that you're in. My sense is that there could be a bit of a difference within each circuit. But generally speaking, again, not legal advice here, to the extent that you really haven't fully litigated the cases, have you really shown that claim preclusion should apply? I think the answer is likely no, but certainly an argument can be made. Terrific. Okay. Next question. Can you amend your answer to plead an affirmative defense if you find supporting evidence during discovery? The answer is yes, you can, and you should. Sometimes you don't know until discovery that, hey, wait a second, the applicant or the opposer knew about this entity for 10 years or longer, and maybe they had some sort of communication back and forth. Maybe there's an actual document that says, oh, don't worry about it. There's no confusion with the marks. Unlikely to get that, of course, but if you were to, I would amend the answer. Why not? Put it at issue, put the opposer on their heels, and definitely think about amending your answer after receiving discovery. Again, another reason to serve discovery early in the proceedings, so you're not waiting until the end to do that. Terrific. Another damages question. Interesting. Okay, I will read it, but I will likely not answer it because, again, I think it's going a little bit outside the scope, but a great question. So thank you for submitting this. Okay, you have an ITU application, and the opposer ends up opposing a later in time application. Okay, then the opposer's mark registers. Can the opposer seek damages in a subsequent litigation? And if so, what date is used to begin calculating damages? I love these questions. They're great, but again, pretty nuanced, including damages calculation. I think a lot of research would need to be undertaken in order to fully answer that. So, terrific. Bree, how much time do we have left? Is it 3 minutes or is it longer? 3 minutes. Wow. Oh, terrific. Okay. Why TTAB proceedings? Why are they beneficial over district court proceedings? Fair question. Again, TTAB opposition does not have oral hearings. You can do everything via paper. You don't have to be licensed in a particular state. Or every state. You have to be licensed in at least one state to practice before the TTAB, but it doesn't have to be California or New York or any other specific state. So you have the opportunity to submit everything on paper. The TTAB judges, in my experience, are very well versed, I should say, in trademark law and precedent. Not to say that district court judges can't be, but I don't think every district court judge out there has a number of trademark cases that they've heard. Maybe yours is the first one, and do you want to be the one explaining it to them why you're in their courtroom talking about infringement? As the applicant, it can be expensive to file a declaratory judgment action too, potentially. So maybe you do want to stay in the TTAB. The worst case scenario, if it's a likelihood of confusion claim, is that your application goes abandoned. Let's say it's an intent to use application. Your client is not using it. Worst case, you lose is the fee, the government fees, and some attorney time spent to prosecute that application. Unless, of course, the applicant filed it themselves, then it's just the government fees to get to that point. What's the harm? In district court, real money's at stake, damages are at stake. If it's an exceptional case, then attorney's fees are at stake. So it's a different world when it comes to TTAB litigation and what you might expect in each respective form? Great question.
Okay. All right, Jonathan. Thank you so very much for this presentation. I know the chat was just on fire this entire time. People were like, "Oh my God, I've learned so much." I conveyed a little bit of that to you here in the chat, where people were like, "It's 11:18, and I've already learned hours worth of material." So we really, really appreciate this presentation. Thank you so very much. I know we've always had lots and lots of questions about TTAB, and so it's incredibly helpful for us.
Terrific.
All right.
Thank you so much.
Up next, we have workshops that will begin at 12:30 Eastern Time. Those workshops are sponsored by Gravity Legal. Pre-registration for workshops was required, and it needed to be done by September 10th to qualify. I did send an email yesterday letting you know what workshop you signed up for and where to go to join that. We would love to have you turn on your camera because workshops are interactive. That's not required, but we would like it. Please do plan to be active and engaged the entire time because you're actually going to be building something that you can use and practicing your skills. So make sure that you're ready for that. If you did not sign up for a workshop, there are a few things that you can do right now. One, you can have a long lunch. I mean, wouldn't that be lovely? Um, Two, we also do have some networking breakout rooms. If you go to the breakout rooms tab, you can go in there and talk to some other people, share practice tips, network, exchange information, do all of the things that make All Legal Connect great. Um, Whatever, you can also do one-on-one networking during this time if you would like. I will see you back here in the stream tab at 1:30 for IP Matters, practical ways that IP lawyers can advance social justice. Thank you so very much, Jonathan, for this presentation, and thank you all for joining us. I will see you in a little over an hour.
Take care. Thank you, Bree.
Thanks so much.